Thank you very much, Mr. Russell. We seem to have the full charter party.
I'm grateful. Lady, we've also had a look over the short adjournment at two of the other standard forms. The shell time, in a nutshell, they are not in the same form as clause 127, in the sense that they don't have the automatic indemnification provision in the event that delivery orders without production are given, but that they still oblige the charterers to comply with an order to deliver without production. So shell time 5, it's clause 33.6, and it's put the other way round. Owners not obliged to comply with any orders to discharge without production unless written confirmation from charterers to do so and an indemnity acceptable to the owners is provided. But although it's put in the form not obliged to unless, it must follow that if the conditions are met, then the owners are obliged to deliver without production.
Possibly, right. I have to look at, I think that's pretty much the form in which the clause was in the Hooder, wasn't it, which was construed as not imposing an obligation. Anyway, perhaps you could just provide us with the clauses.
Yes.
Thank you very much.
What I proposed to do then was to go to the first of the 6 points that I made, which is what is breach. And we say that it is clear on the authorities that any delivery of the cargo without production of the bill, it is a breach of the bill of lading contract. The first case to go to is the Tse Hai Tong Bank case, which is at tab 6. And this is a case in which buyers called Southern Trading wished to take delivery of the cargo from the ship before they had paid, and they got their bank, Tse Hai Tong Bank, to provide a letter of indemnity to the carriers. And the goods were just discharged. Buyer never paid, and so the seller, Rambler Cycles, who had remained the holders of the bill of lading, sued the owners for misdelivery, and the owners then sued the bank on the LOI. And at the hearing on appeal, it was the bank essentially standing in the shoes of the owner, arguing that there was no breach. And the key passage is at page 99 in the bundle. And it's sidebarred. This is Lord Denning giving the judgment of the Judicial Committee. Perfectly clear law that a ship owner who delivers without production of the bill of lading does so at his peril. The contract is to deliver on production of the bill of lading to the person entitled onto the bill of lading. Short and simple, and we say absolutely clear. The next case...
It is an obligation that arises as a matter of contract, rather than as an incident of the bill being a document of title. I think in all the cases I've looked at, it is spoken of in terms of that being a term of the contract of carriage in the bill, but I notice Lord Denning here concludes at the end of the paragraph that gives rise to a liability in conversion, which might suggest that it's an incident of the fact that it's a document of title.
Well, typically the holder will have a claim both in breach of contract and in conversion. The contractual claim arises out of the breach of the term, to deliver only against production.
But the conversion claim doesn't.
No, the conversion claim is
It rises out of a
non-contractual claim.
A proprietary or possessory
Yes.
interest.
Yes, exactly.
But there is a reference to breach of contract earlier in the paragraph.
Yeah.
Yes. Yes, so in this paragraph, you have both causes of action. You have the contractual claim, and it's a breach of contract, and then you have the claim of conversion as well. So the next case is the Sormovsky.
It's a point that may be of some significance, in that if the obligation not to deliver otherwise than against the bill is something that arises as an incident of the bill as a document of title, we're not necessarily concerned with whether the evidence is or contains a contract of carriage. That's why I raised the point.
Yes.
But I think we do see the language of it rising by contract quite frequently.
Yes. Yes, indeed. It's
And that's your submission. It arises as a matter of
it's
contract.
both. Yes, it's both. In circumstances where where the bank is pledgee of the bill, there is sufficient interest in the goods to give rise to the claim of conversion, as well as to give rise to the claim for breach of contract. We principally put our claim as a claim for breach of contract. The next case is the judgment of Mr. Justice Clark, as he then was in the Sormovsky 3068.
I'm sorry, I was just looking at the head note, which mentions conversion, which is on page 89. Damages for breach of contract or for conversion, the latter brought in the consignee and the indemnifying bank as third parties claiming to be entitled to be indemnified by them.
Yes.
I'm sorry, you were taking us?
It's the next tab, so it's
Yep.
tab 7, which is the Sormovsky 3068. It's another case of delivery without production of the bill. And if we pick it up at 107, there's a heading, delivery without production of bill of lading. It says, defendants correctly accept that under the bill of lading, they were obliged to deliver the goods to the persons entitled to possession under it. In this case, since the bill was expressed to be to order, those persons were the plaintiffs as holders of those persons were the plaintiffs as holders of the bill of lading because it had been endorsed in blank. And then it says the most important issue of English law between the parties is whether it's a breach of contract such as this to deliver the cargo without presentation of an original bill of lading. In other words, is it a breach if you deliver it to the person entitled to delivery, the lawful holder, but without presentation? And that was debated, and the judge's conclusion is at 111. And the judge held that it is a breach to discharge or to deliver without production. He says that none of the cases which he's been referred to determines the question. Then he says, just above the second hole punch, it makes commercial sense to have a simple rule that in the absence of an express term of the contract, the master must only deliver the cargo to the holder of the bill of lading who presents it to him. In that way, both the shipowners and the persons in truth entitled to possession of the cargo are protected by the terms of the contract. And he then goes on to discuss the loss point. But in terms of breach, it is, he says, makes commercial sense to have that simple rule. Now, at the top of the right-hand column, the judge contemplated that there may need to be some exceptions to the simple rule, one of which he suggested might be a case where the bill was lost. But we'll see that subsequent cases, in particular the Modus Exports case, have doubted whether there is even that exception. And in the light of this, it's not relevant for present purposes in any event. But this is certainly authority for the simple position that we suggest pertains. So next, we come to the Huda. And the context of this case was rather different. The question was whether a time charterer could oblige the owners to discharge without production of the bill. But obviously, in the context of that issue, the question of whether it is a breach to deliver without production was discussed. And in my submission, it's clear from the judgments of all three Lord Justices that they held that any delivery without production of the bill is a breach. You look first of all at the judgment of Lord Justice Neil, at page 133 in the bundle. He identifies the question: can time charterers lawfully demand that owners of the vessel deliver the cargo without production of the bill? And he says then over the page at 134, at the foot of the left-hand column, no means uncommon in the oil cargo trade for the cargo to be delivered before the bill of lading is received. And he refers to the case with Sigona and the explanation that was given there for the practice. And he says clauses 13 and 50 do not, in my view, impose any express obligations on the charterers to discharge a cargo in the absence of bill of lading. They merely provide for a letter of indemnity if such discharge takes place. I don't construe the clauses as imposing a contractual duty on the owners. So the clause was different from the clause in this case, where clearly clause 30.7 does oblige the owners to discharge. And the judge at first instance had distinguished between the case of a voyage charterer and a time charterer. If you go over to 135, Lord Justice Neil, at the foot of the left-hand column, says that he can see no adequate ground on which a distinction can be drawn between the rights of a voyage charterer and the rights of a time charterer. And therefore he concludes 135 right-hand column by the passage that we've sidebarred. I can see no good reason to depart from the general rule that the owners do not fulfill their contractual obligations if the cargo is delivered to a person who cannot produce the bill of lading. And again makes the point that if that delivery is to the bill of lading holder, there may be no loss. But as a matter of breach, again, it is clear that any delivery without production is a breach. At the end of his judgment, he says, it's a simple working rule. It's, of course, open to a ship owner to decide that he has adequately protected himself by letter of indemnity and to deliver in the absence of the bill of lading. But in my judgment, the rights of a time charterer to give orders do not entitle him to insist that the cargo should be discharged without production of the bill of lading. That is obviously subject to the express terms of the charter party, and we've seen that in this case, the terms are quite. There's then a shorter judgment given by Lord Justice Leggett, and he deals with this issue under the heading delivery without bills of lading. And in the left-hand column, just above the foot of the page, he says, it is an incident of the bill of lading contract, the delivery is to be effected only against the bill of lading. And at the top of the right-hand column, he notes that in practice, if the bill is not available, delivery is effected against an indemnity. He says where the bill of lading is lost, the remedy in default of agreement is to obtain an order from the court that on tendering a sufficient indemnity, the loss of the bill of lading is not to be set up as a defence. So Lord Justice Leggett takes a different approach to the factual difficulty that Mr. Justice Clark had identified in the previous case, where Justice Clark had suggested a term needed to be implied in those circumstances, permitting delivery without production. The bill was lost. Lord Justice Leggett essentially says not so. The carrier's remedy in that case is to apply to the court for an order. And at the bottom of the passage that we've sidebarred, in default of production of the bill of lading, an indemnity is afforded to the shipowner not on account of the lawfulness of the order to deliver, but so as to protect him if he does what he is not contractually obliged to do. And then the analysis in the judgment of Lord Justice Millett, we say is to the same effect. This is at page 139 in the Bible. Again, the heading is delivery of the cargo, otherwise given against bill of lading. And I'd invite Your Lordship to read the entire sidebar passage in due course. For present purposes, if one looks at the passage about halfway down, it has both the fat and thin sidebar. The authorities clearly establish, and the judge accepted, that under a bill of lading contract or a voyage charter party, the ship owners are obliged to deliver the cargo only against presentation of a bill of lading. Foot of the page, last sentence on the page. Once the master has signed a bill of lading and parted with it, he has subjected the ship owners to a contractual obligation enforceable at the suit of any person to whom the bill has been negotiated to deliver the cargo to that person. And then further down the right-hand column, conversely, the master takes an obvious risk if he delivers the goods without production of the bill of lading. He does not obtain a good discharge unless the person to whom he delivers the goods is the person entitled to them, and he's no means of satisfying himself that he is the person entitled except to produce the bill. Now that may suggest that he does get good discharge if he delivers to the person entitled to them. If one looks at the previous passages that I've shown you, in the context of the judgment as a whole, in my submission, it can't mean that it's not a breach, because he has clearly identified already that the obligation, the contractual obligation, is to deliver only against production of the bill. So that's the Huda. And then we have the Motus Exports case, which is at tab 9, first instance decision. And this was a case where the goods had been delivered against the production of a forged bill. And the question was whether the owners were discharged from liability in circumstances where a forged bill had been produced and delivery had been made against the forged bill. It was held, perhaps unsurprisingly, that delivery against a forged bill did not absolve the carriers. And really, there's no suggestion in this judgment, in my submission, that there was any doubt about the nature of the carrier's obligations. If one looks at page 147, under the heading contract, Mr. Justice Ricks, as it then was, says, one must start with the nature of a bill of lading contract, irrespective of any special clauses. It's of the essence of such a contract that a ship owner is both entitled and bound to deliver the cargo against production of the original bill of lading, provided there's no notice of any other claim or better title to the goods. And he sets out some of the cases to which I've taken you already, and particularly sets out the three passages from the Huda. And then at page 149 and 150, he turns to the decision in the case of the Somovsky 3068, which I've shown you. And this referred to, this is the limited exception that had been discussed by Mr. Justice Clark. He notes that the case wasn't cited in the Huda, and notes what Lord Leggett had said. And essentially, if one works one way through the judgment, if one gets to 150, at the bottom of the sidebar passage, we see that Mr. Justice Ricks didn't accept that there was the Somovsky exception to the obligation to deliver only against production of the bill. And then we can pick it up in the Court of Appeal at tab 10. And if we go to paragraph 19 of the judgment of Lord Justice Stuart Smith, with which both Lord Justice Mummery and Lord Justice Mance agreed, paragraph 19 on page 166, Lord Justice Stuart Smith says in clear terms again, it has been established for well over a century that under a bill of lading contract, a ship owner is both entitled and bound to deliver the goods against production of the original bill of lading, provided he is no notice of any other claim or better title to the goods. He says it seems probable that the importance of the obligation stems from the negotiable nature of the bill of lading. But my submission is it's clear that it's still a contractual obligation. And similarly, paragraph 4 of the judgment of Lord Justice Mance, over the page on 167, it's the first sentence of the judgment. He takes it as read, essentially, that subject to any particular clauses in the bill, the carrier's duty is to deliver only against presentation of an original bill of lading. So we say on very high authority the proposition that any delivery without production is a breach is very well established. And as I say, the judge erred in her analysis in failing to take that firmly into account when she carried out the analysis that she did. And then that leads into the second of my 6 points.
So how does that work where the shipper, charterer, remains throughout the holder of the bill and asks for discharge, but someone asks for discharge? There's never any contract, so is there never the contractual obligation only to discharge against presentation of the bill?
Well, in that circumstance, the only effective contract will be the charter party, and therefore what the owner is obliged to do will be determined by the terms of the charter party, which may vary from case to case.
So this rule doesn't apply in that circumstance.
That must be right. It's in circumstances where the only contract that is at that point in time in force is the charter party. But what one has to remember is that if the bill of lading is subsequently transferred, so that a contract springs up in circumstances where the bill is not spent, then the owner has put himself at risk, and so owners will, even in that circumstance, either require reduction of the bill of lading or an indemnity to prevent themselves being exposed to a bill of lading contract which subsequently comes into force. And obviously, a fortiori, if the transfer has taken place from the charterer to a new holder before discharge, then at that point it's a two-contract situation, a three-party two-contract situation. And the carrier has obligations under both the charter party and the bill of lading contract.
Seems rather odd that the mantra that the shipowner is obliged to deliver only against presentation of the bill itself, regardless of who the true owner is, should depend upon whether the bill does or doesn't contain a contract of carriage. I can quite see that may be the contractual effect of it, where there is a contract. What we're talking about here are circumstances where it may not have contractual effect.
Well, if it never has contractual effect, then the charter party will be the governing contract.
Or if it ceases to have contractual effect in a Dunelmian situation.
Yes, but I mean the practical reality is that a carrier will always wish to protect itself, either by requiring presentation of the bill or taking a letter of indemnity, because otherwise it faces the risk that the either there may already have been a transfer, or there may be a transfer which is effective to create a claim, even though the transfer takes place after discharge. I mean, it's one of those things. The practical reality is that the carrier, until the bill is presented, will not know where the bill is, or whether a bill of lading contract has been or may be created, which is why, as the authorities say, a carrier who whatever the circumstances, discharges without production, delivers without production, puts himself at risk.
But as it happens, he doesn't put himself at that risk if the bill isn't at that stage of a contract. He may or may not know that. I quite understand in practical terms he might not. It just strikes me as slightly odd that the obligation, which is an obligation, as you've pointed out, not simply to deliver to the right person, but to deliver against a bill of which you're in breach, even if it is the right person,
Yes.
doesn't apply if the right person is the charterer.
Well, the important point is that the ship owner, in those circumstances, delivers at his peril without production of the bill, because even at that point in time, the bill is still in the hands of the charterer.
Well, I understand that as a matter of practicality.
Yes.
It's just slightly odd that as a matter of juridical analysis, the obligation exists in one case and doesn't exist in the other. Which wouldn't be the case if actually, despite what's said in the authorities, it's an incident of issuing it as a document of title, rather than a consequence of it being a document which sometimes, but not always, contains a contract of carriage.
Yes, I mean it's the claimant conversion will probably not work if delivery is to the owner. It's not. But your lordship's analysis presupposes that, as I understand it, presupposes that there is.
Well, it will in the contractual analysis, because as I read these cases, there's a contractual obligation, not just to deliver to the right person, but against the bill.
Yes.
So
if that presupposes that the bill has contractual force.
Yes.
Whether that contractual force is gained before discharge or after discharge by way of a qualifying transfer under Cogsum.
All right.
In my submission, none of that detracts from the proposition that once a bill of lading has contractual status, then it is always a breach to deliver the cargo without production of the bill. As carriers know, as Mr. Van der Haar said in his evidence, carriers know that they breach the bill of lading contract, if there is one, by delivering without production of the bill. And the second point that I make is that the judge has not, or is certainly not adequately, addressed or had in mind the fundamental causation question, which is whether the breach was an effective cause in law of the loss. And as I said before, it is important that analysis is carried out, given the obvious causative potency of the breach in this case. And it feeds it into both a factual analysis as to whether something else can be said to be the sole effective cause of the loss that in fact occurred, such that the breach is not an effective cause. And it's also relevant to a counterfactual analysis to the extent that that is legitimate. at all. Because in deciding whether on the counterfactual something else would have had the effect of denuding the breach of its status as an effective cause, one has to consider the causative potency of that breach. And we simply we don't see any analysis to that effect in the judgment. It comes back to what we say is the crucial point, that but for the breach, the cargo stays on the vessel. And if the cargo stays on the vessel, then the bank doesn't suffer the loss of its security interest. And that chain of reasoning, which is crucial to any proper analysis of causation, whether it's in the facts as they occurred or on a counterfactual basis, is simply not there in the judgment. The third point, I'm not sure there's much to add to what I said in my initial summary. Third point is the lack of clarity in the judgment as to what the judge was in fact deciding, whether she was deciding that the bank had caused its own loss on the facts that occurred, or whether she was addressing a counterfactual analysis. So some of the findings are consequently hard to interpret, we say. So, for example, the findings are so shortly stated. It really, the findings that the judge makes are limited to paragraph 61, which is page 56. Where she refers to our counterfactual on quantum, and says, in my view, the key point for this purpose is that on the bank's case, BP was the lawful holder of the bill at the time. Yet the claimant nevertheless accepts that it's reasonable to assume that the bank would have been involved and would have sought to give instructions to the owners, albeit that the bank's case is that they would have told the owners not to discharge the finance cargo. Now, this is relevant both to my third point and to my fourth point, which is the adoption of an entirely unrealistic counterfactual. What we were doing was not addressing causation in our counterfactual analysis. We were setting out a purely hypothetical sequence of events that nobody was suggesting were going to happen in any reality.
Well, that's what a counterfactual is. It's a hypothetical series of events.
Well, of course it's a hypothetical series of events. But when it comes to causation in my submission, there is a difference, and deciding whether what would otherwise be an effective cause of loss loses its causal efficacy. There's a difference between a sequence of events that might have eventuated and a sequence of events which would and could never have eventuated. And the latter is a legitimate exercise for the purpose of trying to put a value on the quantum of our loss. But is not legally relevant for asking the question, is the breach an effective cause of the loss or not?
So just trying to understand that a bit better. Are you saying because of what you describe as the causative potency, the hypothetical or the unlikely nature of the counterfactual scenario is irrelevant or decreases in importance?
So what we say is that one cannot say that a breach of contract is not an effective cause of the loss, where the counterfactual that's posited in any event is one which is common ground, could and would never have eventuated. One can't say the loss would have happened in any event if the in any event was never on anybody's case going to occur.
So there may be no counterfactual. I think
there's no relevant.
There is no relevant.
No relevant counterfactuals available. In the way in which it was put in the owner's closing, there was no available reality in which there would not have been a misdelivery. Again, we say that the lack of clarity in analysis in the judgment between the two different exercises has contributed to the judge's failure to identify the obvious causative potency of the breach that in fact occurred.
But the judge's recording there of the bank's case nevertheless accepts it's reasonable to assume that the bank would have been involved and would have sought. What's the silent if? Would if what?
Well, would have become involved if there had been no breach. But there was always going to be a breach. That's the owner's own case, was that there was always going to be a breach. There's nobody countenance a set of events where there would be no breach for this counterfactual ever to arise. Situation where owners do not comply with the Charter's instructions and seek to involve other parties is one, as Mr. Van der Haar said, that he simply never come across, because the owners always rely on the LOI.
You started your submissions by saying, I thought, that was what had been said, but that was in the context of arguments on quantum, not
yes.
Causation.
Yes.
But what is the if in the context of a causation argument? What was your if in the context of your causation argument? For the would have.
Well, sorry, our argument was for the purposes of assessing quantum rather than what our case was looked at. If in the purely hypothetical world there had been no breach, what value is to be ascribed to the loss of our security interest by reference to the date on which we could reasonably have sold the cargo? It's important to stress, Lord, my ladies, that this counterfactual analysis is a matter of causation.
So it is the same if. Is it?
Yes. Yes.
It would have been involved and would have sought to give instructions, square brackets, if there hadn't been a breach by discharging the cargo.
Yes. But it's completely different asking whether the counterfeit factual is effective to displace the efficacy of the breach as an effective. I'm sorry, losing but the number of effectives. To discharge the efficacy of the breach as an effective cause of the loss, and identifying what, in a sense, notionally is the value of the security interest by reference to when it would have been possible to sell the cargo.
Is clause 30.7 at all relevant to this, in the sense that on the BP form actually positively required the owners
Yes.
to discharge?
Yes, I mean,
They didn't, looking at that contract, they had no choice. If you look at that contract, they had no choice.
Exactly. I mean, as a matter of practical reality, see the witness evidence, they were always going to comply with the charterer's orders, which means breaching the bill of lading contract. But as Milady says, they were, a fortiori in this case, they were contractually bound to the charterers, to Gulf, to discharge, to deliver without production, and therefore to breach the bill of lading contract.
But there was a way in which they could avoid breaching either contract, which was to ask for the bank's consent.
Well, not the bank's consent, because the bank isn't the bill of lading holder at this point in time. The bill of lading holder
Ask for BP's consent, which in the end would have meant asking for the bank's
Yes.
consent. Yes, asking for BP's consent.
Yes, I mean, it's a theoretical possibility, but no more than that. But because in the real world, as I say, that's never going to happen.
Well, you may say, so far as the findings are concerned, we can't assume that the bank would have consented if they'd have been asked to give express consent, because they'd have sent it off to their legal department, who've said, "Oh, hold on, that means we're giving up our security interest."
Yes.
We're not going to do that without some other form of security, or however that may be.
Yes.
And your criticism of the judge, if the right formulation was the sort that I described, rather than the simple stop because the breach is a breach,
Yes.
is that the judge has never gone there and addressed those questions.
Well, quite. And that's obviously my sixth point, which is that to the extent that this is a legitimate exercise at all, there is nothing in the judgment that comes close to. There are no findings of fact in the judgment that come close to establishing that in this counterfactual world, we would not have been entitled to bring the same claim that we bring in this action.
And what's the consequence of that if you're right? If that's the stage at which this point falls to be decided, and the judge just didn't apply the right test or apply her mind to the steps that needed to be addressed, does the matter have to go back for the right question to be asked and answered on the evidence? Or on fresh evidence if it has to go back before a different judge, which it might?
Well, no, because we say that on any view, the breach must be viewed as being an effective cause of the loss. And there are no findings of fact in the judgment to provide any basis for saying that it ceased, it lost its causative potency and was not an effective cause of the loss, despite the prima facie causative potency. There's no reason for the owner to have a second bite of the cherry. A fortiori, it's very important to emphasise that this was not part of the owner's pleaded case whatsoever. Nowhere in the owner's pleaded case do you find an argument that there's no argument anywhere. If we had not been in breach, this is what would have happened. And there is certainly no argument that if we had been in breach, we would then have discharged without production of the bill of lading a few days later. But we would not have been liable because X, Y, Z.
So what was the no causation argument that you were facing?
It's not entirely easy to unpick. The owner's main defence appeared to be that BP had authorised the discharge without production, the delivery without production, by way of the novation.
Well, I understand that, but that's a separate point. We've seen from the list of issues that one of the issues which is recorded as an issue is, did the breach cause the loss? And there was obviously an argument from the owners that it didn't.
Yes.
And I'm just asking what it was about that argument that means it was put differently from the way I've been articulating it, so that it's not open to them.
Well, I mean, certainly the way in which Ms. Bodnaya was cross-examined was along the lines, if Gulf had asked you, may we discharge by STS, she would have said yes. Now, we don't see how, as a matter of analysis, that could ever lead to a conclusion that the breach was not an effective cause of the loss. Even that line, so what you would have done, wasn't part of the pleaded case.
And the critical bit that was missing, you say, was what the bank would have done if asked by the owners.
Yes.
To sanction BP's consent or give their direct consent vis-a-vis the owners, rather than in their private discussions with Gulf.
Well, yes. I mean, no analysis of what the bank would have done in any detail whatsoever.
Because speaking for myself, the prior stages might not need much heavy lifting, as you described it. If the owners had said we're not going to discharge without production of the bills, the stages at which they would have then said, who's got the bill? Can we have consent from the bill holder? And that ending up with requiring the bank's consent might be thought to be stages which were pretty self-evident.
Well, it's difficult to say that they're self-evident. I fear I may be repeating myself. In circumstances where the owners never do this.
Well, I quite understand you say we can't take this as a hypothetical because it wouldn't have happened.
Yes.
But suppose you're wrong about that, and we get to your stage 6.
Yes.
Which is, well, that isn't what the judge did, and I'm just interested in trying to clear my mind on whether, if that were the bit that mattered,
yes,
the result is we simply say that the defence of no causation fails, or that was an issue, the judge hasn't properly dealt with it, it's got to go back to be dealt with. And that's where I'm on.
Yes. Well, it'll not surprise you.
Obviously, you say the first.
We say
and that's why I'm asking you what their causation argument was.
Yes. Well,
that was fatally deficient, as it were.
Well,
compared to this line of reasoning.
I mean, it sounds like a cop-out, but it's not entirely clear to us that there was ever a causation argument that was articulated that could ever have worked. It's as I say, it's not pleaded. There was no evidence led by the owners as to what they would have done in a no breach scenario. A detailed analysis of the counterfactual circumstances acts by the owners, acts by BP, acts by the bank, then acts by the owners in reliance on whatever the bank has done. It was never part of their case.
Well, it looks as though Mr. Van Guy's evidence was, well, in the end, I turned it over to the legal department and asked them what to do.
Yes. I mean, there was, as I say, not part of the pleaded case at all, and no evidence beyond what Mr. Van der Haar said in cross-examination. But again, his evidence was, well, that's never happened. I think really, the way, although there was the loss would have happened in any event in the pleading, there's no particularisation as to how that developed or how that would work in any way. I mean, the irony of it, to a certain extent, is that the causation argument that was being run at trial was really the other causation argument, that the bank caused its own loss because of the way in which
because of its financing.
Because of its financing arrangements, yes. So I mean, although the if we, it may be necessary for the court to sort of work through the amended defence and see the different ways in which way. Although my recollection is that there is, and in any event there, there's none of the analysis that your lordship has identified would need to be carried out to support a no causation finding at stage 6. That the bank's causation, that the owner's causation argument was essentially you've caused your own loss because you have or would have given permission to Gulf. I mean, there's obviously another entire layer of unreality to the way in which the owner's case was put, because it seems to be predicated on us giving instructions to Gulf, and then Gulf doing what we want in circumstances where Gulf, as we now know, were fraudsters. So there's at least another missing link in the chain, if I can put it that way, in the owner's case, which was predicated on the bank speaking to Gulf, not giving instructions directly to owners.
Thank you.
So we were on point 3. I think we've gone on, perhaps.
Well, I think we've probably sort of taken 3, 4, 5, and 6
Exactly.
all somewhat together, and one tries to break it down into a structured analysis, but inevitably these issues do overlap to a certain extent. Just picking up on the point that your ladyship made, in the bank's pleading at it's in the core, tab 10. At paragraph 67, you see that at the last sentence of paragraph 67, the owners actually pleaded that by the terms of the charter party, the defendant was obliged to deliver and discharge the cargo without production of the bill, if instructed to do so by the charterers, which it was. And at paragraph 71, they make the point that if the claimant wasn't the lawful holder of the bill of lading, and the defendant was not obliged to deliver the cargo. I say, no part of the pleaded case that they might not have breached the bill of lading contract, or what would have happened if they had not breached the bill of lading contract. And therefore, in circumstances where the judge has, in a wholly inadequate way, we would say, carried out an analysis that wasn't even being advanced by owners, it would be wholly wrong to say that they're entitled to have a second bite of the cherry now. In circumstances where the judge's findings of fact are wholly inadequate to justify any legal analysis as to why the bank has lost its right to claim.
Is paragraph 77 where we see the beginning and end of the causation? Apart from putting to prove at 76.
Yes, I mean, 77 is the argument that the finance cargo was delivered to God with the authority of the claimant, such that it hasn't suffered any loss and damage. I mean, as a matter of legal analysis, that doesn't work. Yes, I mean, that's the caused error and loss point. But one then has 77.2, and then one gets into the amended section is all dealing with our
Quantum.
Point.
Right, so paragraph 3 on page 25 talks about the counterfactual hypothesis being that the cargo hadn't been discharged.
Yes, that's all responsive to our counterfactual that have taken about 12 weeks to sell the cargo. And then in any event is at the very end of 81. And one has putting us to proof that the alleged loss wouldn't be suffered in any event. To which we say, well, that's where one comes back to that one does come back to the simple analysis. If there'd been no breach, there would have been no loss.
Thank you.
Lady, as I say, I haven't sort of followed the
No,
neat structure, but unless there's anything else I can assist the court with on that second ground of appeal, what I propose to do is then briefly address the respondent's notice points.
that's fine. Please do go on, but also don't be fooled by the clock because it's slow and it's 3:05.
Right.
So, respondent's notice.
Yes, so if we perhaps just go to that respondent's notice. It's at tab
13? 13?
yes. Tab 13, yes. And the first ground of appeal, or respondent's notice ground, sets out quite a number of different arguments that don't seem to be pursued in the skeleton argument. So, for example, 1D, that the bill of lading was spent, no longer seems to be pursued certainly in the skeleton argument. As we understand it, the argument that's now made in the skeleton argument, it is that this is really at 178 in the skeleton. Once it starts at 177. As we understand it, the argument is that BP requested or authorised or consented to delivery without production. And that consent was communicated to the owners, and that therefore there was no breach, or in some way the owners are not liable. And again, as we understand it, there are 2 points that are relied on for BP's conduct. The first is the supposed invocation of the LOI, which was on the 12th of March, so long before any discharge or orders were given. And that's the point that was unpleaded in the pleadings and wasn't pleaded at the trial. And then the novation is also relied on. It said that by the novation, BP agreed that Gulf could give orders as to discharge without production, which then Gulf did. So that's 2 and 3 in the respondent's notice seem to be part and parcel of the same argument. And then there's the BP's subsequent failure to object when it was copied in on exchanges, and that wasn't pleaded. The failure to object when copied in wasn't pleaded. There was no application to amend. Now, on the first point, it's right that we didn't seek to have the invocation of the LOI excluded from the argument at trial on a pleading point basis, but it's not dealt with in the judgment at all. We do say that it's one thing not to take a pleading point in a trial, but another entirely to have to deal with that unpleaded point on appeal in the absence of any findings on the point at all in the judgment. And so formally we do maintain a procedural objection to parts 1 and 4 of this argument in the respondent's notice. Without prejudice to that, and looking at the merits of ground 1 as a whole, for the reason we've already analysed.
I'm not sure I understand that point. At trial, pleadings are intended to identify the arguments which the parties can and can't run in the case. It not uncommonly happens that a spat arises and someone says this isn't pleaded, and what happens is what happened here, which is, well, despite the fact that it's not pleaded, we're not taking a pleading point, i.e. that is an argument which is in the arena and is being dealt with and is being addressed. So for the purpose of an appeal, it's no different from any other argument, is it, that was in the arena but the judge hasn't dealt with?
Well, it's certainly right that the judge hasn't dealt with it. I can't take it any further.
No, right.
And it doesn't matter because we say that ground 1 is without any merit. I say the starting point, as we've analysed going through the authorities, is that any delivery without production is a breach of contract. And so there has to be some other route by which owners seek to escape liability based on this grant. So it would have to be some sort of waiver of performance or in the sense of an equitable forbearance, we suggest. As to the supposed, and there's nothing that could possibly amount to a defence to a claim in any of the facts that are alleged. So if we look at the supposed invocation of the LOI on the 12th of March, that can't possibly mean that either there was subsequently no breach or that performance was waived in either way. I don't need to take you back to the wording of clause 30.7 if you have it firmly in mind. You'll recall that it is the automatic provision where if the bill isn't available at the discharge port and charterers give instructions to discharge with or to deliver without the bill, then the indemnity is deemed to have been provided. The supposed invocation exchange is at tab 10 in the supplemental bundle. I think that's the first of the two supplemental bundles. And in the usual way, we have to start at the end of the tab and work our way forward in time to the front of the tab. So if we start at page 51, the first message on the 11th of March is from owners in Euronav to BP's brokers. So Colin Weston of Potent is BP's brokers. Any extra details regarding the discharge orders?
Have we got the email to which this is a response?
I don't believe we do.
Because if you look at the title, it looks as though what's meant by discharge orders was simply asking about ETA and details of the agents.
Yes, yes.
So not really discharge in the sense that we're using it for the purposes of clause 37 yet.
Correct, correct. And we'll see what's said. At its highest, it's the orders are orders to go to Fujairah for orders. So there are no discharge orders given at all.
All right.
But I don't believe that we ever had anything predating this disclosure as part of this exchange. Right. And obviously, bear in mind that these are exchanges that, so far as the bank is concerned, it's entirely unaware of any of this taking place. These are all exchanges on the owner's side of the fence. And then at the top of the page, the response from the brokers is the next day, 12th. Good day, have requested advice in regards to discharge orders again this morning and awaiting response. However, in the meantime, and just to ensure mutual understanding, can you confirm that LOI is an invocation in line with Charter Party Clause 30.7? I'm not going to attempt to explain what that means. I have no idea what it is supposed to mean. And it's not clear whether this is an inquiry that's being made by the brokers of their own bat, or whether this is BP seeking information, or inquiring, or BP doing something. I mean, it is striking that, just to contrast this message with the message at the foot of page 49. When BP do give orders, the orders from BP are set out in quotes in a way which is very common by the brokers. But there's no equivalent in the message on page 51 to suggest that this is the brokers formally passing on something that BP were doing. And I mean, this is, in my submission, not fertile ground to find actions on the part of BP which result in the fundamental right of the bill of lading holder to make a claim in the event of delivery without production. So then the response is in the middle of page 50. Euronav say, hope we will receive discharge order very soon. So accepting that no discharge order has been given, and it being the discharge order that is the trigger for the LOI. And we say, we agree that LOI is an invocation in line with clause. Yes. my submission is the same as your ladyship's. I don't know.
Well, they knew what they were talking about, and it might be sensible to construe it, both the request and the confirmation, is are we agreed that when we give discharge instructions, that will trigger clause 30.7 and therefore will have the deemed indemnity,
Yes.
which the giving of discharge instructions invokes.
Yes. I mean, given
That's the sense of it. It may not be beautifully.
No,
It may not be beautiful language, but
no, and I mean,
that's the sense of what's being asked to be confirmed, isn't it?
it probably is. I mean, another way of putting it might be to say, are we agreed that the charter party means what it says in this case, or the terms of this charter party is that there will be an automatic LOI if the relevant discharge orders.
Well, and that discharge orders,
Will
when we give them, will have that effect.
Will have that effect,
They'll
yes.
trigger 30.7.
Yes, it's perhaps confirmatory of what clause 30.7 says and means. Maybe the best way of looking at it. Then the orders, which, as I say, are set out in quotes. Charters advise current instruction to owner's master is for vessel to head to the Jera and wait at anchorage for further discharge orders. So that clearly doesn't trigger the LOI. And there's an acknowledgement. And as I understand it, that's it. So that is that's not an authorization to discharge or instruction to discharge without production of the bill of lading in any way that would discharge the owners from a subsequent breach of that obligation. I can't. How puts it, but I can't really put it any more clearly than that. And the second matter that's relied on is the novation. And I made my submissions in relation to the novation when we were looking at the document. It is a novation of the charter party obligations, subject to the carve out in relation to accrued rights and liabilities. But there's
Well, sorry, just to go back to your first point on the 12th of March.
yes,
It might be said that this is, given what was said about clause 30.7, this is an instruction that when we give our discharge orders, which we do shortly thereafter, they are to be taken to be discharge orders that you should discharge otherwise than against the bill of lading in a clause in accordance with clause 30.7.
yes,
I understood your points to be, well, that's at a time when BP were the charterer, and the relevant discharge instructions that we're concerned with come from Gulf later, so these aren't the relevant
yes,
discharge instructions. And in any event, even if these were the relevant ones, this is at a time when, prior to the novation, on any view, the bill of lading is a mere receipt, whether you call it a suppressed contract or not.
yes.
And what is done is clearly done qua charterer and can't be treated as being done qua holder of the bill of lading, so as to involve any waiver or acquiescence in relation to rights that arise under the bill of lading contract.
Quite so.
I think those were the 2 points I picked up from your skeleton.
Yes, and furthermore, in any event, requiring discharge against an LOI or directing for discharge against an LOI is not consistent with a waiver of the bill of lading rights, because ex hypothesi, the owner will understand that he's breaching his bill of lading obligations, but is obtaining the LOI in response, in return. mean, again, I'm taking this quite shortly because we have set out our arguments in the written skeleton, and we obviously rely on you adopt fully what's in this skeleton. In fact, if I don't say something orally, it doesn't mean that in any sense it's not relied on as the court will understand. Similarly, in relation to novation, I mean, if one wants to look at it again, it's at tab 24 of the supplemental bundle. So tab 24, page 83. And there's nothing in the novation agreement that could possibly be construed as clothing Gulf with authority to give instructions on BP's behalf in relation to the bill of lading contract in such a way as to waive or create an estoppel in relation to bill of lading holders' right to bring a claim for that breach. And a fortiori in relation to the suggestion that BP didn't object when they were copied in on correspondence as to the discharge arrangements that were being made. There's no way in which mere silence on the part of BP could constitute a defence to a claim for breach by owners. And we also rely, again, this is in the skeleton, there's a passage in Aikens, paragraph 9.66, which is for your notes at page 320 in the authorities bundle, to the effect that any estoppel against BP wouldn't operate against a subsequent holder of the bill of lading. The BP were holders at the time. Therefore, anything that they said or did, whether through directly or through Gulf or otherwise, can have no impact on our claim. The second ground of the respondent's notice is then the causation ground that the bank caused its own loss. And again, we've probably covered this sufficiently as we've gone through round 2 of our notice of appeal. One has to have firmly in mind the causative potency of the breach. It is the breach which is the effective cause of the loss, or an effective cause of the loss. And there is nothing in the nature of the underlying transaction, which means that either there is no breach, or that the bank is in some way debarred from bringing its claim. If necessary, I will pick up on the respondent's notice point in more detail in my reply submissions. Then the third ground is it's an argument that we have failed to prove that the cargo was not delivered to the approved sub-buyers. In other words, the 6 sub-buyers that we had understood the cargo would be delivered to, and in respect of whom Gulf had said that they had trade credit insurance. And the owners, as I understand it, they say the judge hasn't made a finding on that point, and therefore, even if the bank were to succeed on its grounds of appeal, there is a live issue of fact that needs to go back to the trial judge. And we say that that's wholly wrong. There is no need for a finding on that fact at all. It's not entirely clear, again, how the case is put, because it's put in the thinnest of terms in the skeleton argument at page 184. paragraph 86, it said the bank's pleaded case repeated at trial correctly proceeded on the basis if the finance cargo was delivered in a manner to the recipients approved by it, it would have no claim. We do not for a moment accept that that is was our case at trial. I'll show you paragraph 36 of the reply in a moment. We say that the question of to whom the cargo was in fact delivered is entirely irrelevant, either to the question of breach for the reasons I just outlined, or in the counterfactual world analysis to any inability to make the claim, because the findings of fact are so wholly inadequate. But particularly again, when one bears in mind that the lawful holder of the bill at the time was BP and not the bank. As to the supposed admission, it is important to look at what we said in paragraph 36 of the reply. Paragraph 36 of the reply is at page 143 of the court. And it is responsive to paragraph 47 of the amended defence. And paragraph 47 of the amended defence is at page 122. So have a finger in each page. Paragraph 47 says that as at the 4th of May, so that's just after discharge has been completed, the claimant made no complaint to Gulf, or indeed the defendant, that the financed cargo had been delivered / discharged, or that it had been delivered / discharged without production of the bill of lading. No such complaint was raised because, as set out above, the claimant had authorised delivery / discharge of the financed cargo without production of the bill of lading in order that the sum lent to Gulf could be repaid. And what we say at paragraph 36 is no complaint was raised by the bank on the 4th of May because the bank believed at the time that the financed cargo had been delivered to the approved sub-buyers at the terminal at Fujairah, and thus it had nothing to complain about. And the words that are leapt upon by my friend are, and thus it had nothing to complain about, which he turns into an admission that if it went to the approved sub-buyers, we had no good claim, and in that sense had nothing to complain about. That's plainly not what this paragraph is going to. All we were saying was that on a narrow factual point, at the time we believed that Gulf had done what Gulf told us they were going to do, which was deliver at the terminal at Fujairah. And because we believed that was what had been done, we had nothing to complain about, in the sense that what we thought was going to happen had happened. That's all it means. We do not for a moment accept, for all the reasons that we've set out, that the fact that that in one sense what we thought was going to happen had happened would prevent us from bringing a claim. In any event, we say that the factual allegation the factual issue that the goods, whether the goods went to the approved sub-buyers or not, is not one that was open to the owners on the pleadings. The owners' pleaded case was that the cargo was delivered to Gulf. We can see that in paragraph 66 of the amended defence, which is at page 127 in the core. So page 127, paragraph 66, the owners plead that they delivered and discharged the cargo into Couch Bay and Prestigious. And they say the defendant thereby delivered / discharged the cargo to Gulf or to its order. So not to the sub-buyers, a positive plea that it's delivered to Gulf. Similarly, at paragraph 77.1, which is at page 130, finance cargo was delivered to Gulf with the authority and approval of the defendant. And we filed a request for further information, and the response to that at page 317 in the supplemental bundle, so in volume 2 of the supplemental bundle. They said that the defendant's case was delivered to Gulf or to Gulf's order, and that they didn't know whether it was delivered from Couch Bay and Prestigious to the sub-buyers. And the owners applied shortly before trial for permission to amend to plead a positive case that the cargo was delivered to the sub-buyers. That application was refused. So, if it were to matter, which it doesn't, this is not a case that's open to the owners in any event. And the reason why it was refused was it was late, but because it was late, we had been prevented from making any further factual inquiry. So we would have been prejudiced by the late amendment because we lost the chance to investigate if owners were going to say it was relevant. There's a quite careful judgment in the bundle dealing with the amendment application. Lady, if the clock were accurate, I think I would have hit my timing.
But it's not. Thank you very much indeed.
Unless I can assist further.
Thank you very much indeed, Mr. Russell. Mr. Thomas.
My lady, if I might just firstly rearrange the furniture ever so slightly. My lady, as so often I think in the respondent's position, one finds oneself in a slightly unenviable position where the goalposts have moved somewhat, things have moved on. So if I may advance an apology at this stage, to say if I'm covering matters which are no longer in dispute and which we have reached some common ground on, do excuse me for that. Nevertheless, before I come to the specific grounds of appeal, I do wish to just dwell for a brief moment on the appeal and the appellant's approach to it. First thing I want to do is briefly reflect on the result for which the bank contends in this case. Now that result is as follows, they say that notwithstanding the unchallenged finding that the bank would, if asked by the ship owner for the bills of lading, have in any event permitted, authorised, consented to discharge in the very circumstances that caused its loss, it nevertheless has a claim. That is a summation of Mr. Russell's case here today. However beguilingly he may have put it, that is the bank's case. It'll not surprise you to hear we say it's a remarkable result to contend for. We accept it may be a result that you feel driven by some principle of law to find is the correct one, but the very nature of the result, extraordinary as we say it is, must, we submit, give serious pause for thought as to whether it can possibly be the right answer. And we'll come to see in the context of the causation argument in particular that what we see today is a very different case to that run before the judge and indeed in the skeleton argument on appeal. But the second point relating to that is that in light of the unchallenged findings made by the judge, the appellants choose, or perhaps more accurately are forced, in order to persuade you to endorse the result for which they contend, to advance a significantly different case. We'll see, for instance, that, and we've heard for the first time today, I think, that the bank now contends, amongst other things, the very question that it asked the court to consider in the context of causation is the wrong one. And we'll come to this. My learned friend says it was all about quantum. It wasn't, and we'll see that in the documents and submissions. In fact, as I understand what my learned friend has just said, in alluding to the last submission he made about delivery to the sub-buyers, it's now the bank's case that even if discharge was made at its specific direction and with its express authority, that is no defence for a ship owner. And that's a very different case from the one run below, and it's an extraordinary and we say wholly untenable one, but it's what the bank is driven to submit in order to try and overturn the judgment against it. At the same time, it is forced, and does so with some vigour, to criticise the judge. We've heard a lot about lack of clarity, no findings on this, no findings on that. It does so in manners, my submission, are totally unjustified, not only in respect of arguments that were not addressed in the judgment for the reason they were not advanced below, but also in respect of arguments that it did advance, but didn't work because the judge's findings of fact meant there were no defence. And the same example can be given. Mr. Russell's complaint of an absence of evidence on certain aspects in the judgment comes only from the fact that he didn't advance the theories or posit the scenarios which he now does to this court. And it lies, we submit, ill in the bank's mouth to complain about the absence of finding, or indeed rely on the absence of findings in trying to stifle any remission, or indeed in trying to avoid the consequences of its new case. And indeed, to Lord Justice Popplewell's point, the list of issues was provided to guide the court as to what was to be decided, and that was a list of issues provided by the bank. So my learned friend says, oh well, actually this issue wasn't really what it's all about. It was their list of issues to which we in due course agreed.
It's an agreed list of issues.
It was. But it's no good to criticise the judge for not following that and dealing with the questions in it when that is what she was asked to do by the bank. And thirdly, in its attempt to thread what we might call the proverbial legal camel through the eye of the needle, the appellant has taken quite a lot of time in seeking to persuade the court of the untold damage that this judgment will do to international trade. Now, the court, I'm sure, will have heard this often deployed in argument before it, we submit it is no substitute for a coherent legal analysis, which is what is absent in this case on both grounds of appeal. We do submit, and we're not going to go on at the lengths Mr. Russell did earlier, but we do submit that the facts of this case are unusual. We don't accept the results of the judgment are in any way coherent, but they are the results of the very specific facts with which the judge had to deal. And just a couple of examples. I'm sure you will have formed your own views, but certainly in my experience, the occasions on which you have an ovation of a charter party, a bill of lading left out there in the world is a rare one. Even more so, as Lord Justice Popplewell indicated, this is not, if you like, a straightforward novation. It is one where some rights are left in place and others are prospective. There's a prospective novation. That's an unusual scenario. And so what the court was addressing was the facts it had before it. And we say that the analysis is the correct one, the consequences are correct. To the extent there is any anomaly, we say it's more a phantom of the bank's imagination than anything else. And in that context, my learned friend referred to the bank's concern more broadly. Well, there's no evidence to support reaction in the trade more broadly, and indeed no evidence to indicate whether they fully understand the findings on the basis of which the judge came to her views. So we ask you to put that out of your mind and to look at the case on its merits rather than in light of some perceived damage to international trade more broadly.
You say the novation is unusual. It was provided for in the sale contract. So it was in the sense that it was something which the parties agreed, if Gulf wanted, BP would cooperate with and seek to achieve with the owners. And its anticipated purpose was what? To enable buyers to give discharge instructions without having to go through the sellers.
My lord, that was never...
What's the commercial purpose of it?
That was never investigated at trial. There was a message from BP. My clients asked why BP wanted to novate, and there was a rather cryptic message. I'm not going to try and remember what it said. It was quite a cryptic message. We can certainly provide it for your lordship tomorrow. It certainly isn't the explanation your lordship has just indicated. So the precise reason, I think, may need some interpretation.
Do you have any submission, just objectively, why it is that someone in the position of these buyers and sellers would want to have a novation from the start?
Well, if I might reflect on that and come back to you. It's not an issue that's previously been raised, so I will reflect on that overnight if I may, and come back to you if I do have any submissions.
Thank you.
So the overview of our case, my lady, is that we say the judge was right for the reasons she gave, as you'll understand, and that even if that is not the case, there are three further grounds upon which the judgment and the order consequent on it should be upheld. The question, of course, raises ugly head as to whether, if you were against this, remission might be an option, and we'll, I think, address that as we go through. But it's certainly one of the possibilities. If my learned friend's complaint about the lack of findings is a fair one, then on a number of issues in our submissions would have to go back to the judge or maybe to another judge. And we do highlight at this stage that the judge didn't actually make a finding owners were in breach. She actually proceeded on the assumption of breach, and you'll see that from paragraph 51 of the judgment at paragraph 53. Just so what's actually decided in the judgment is clear. Her ladyship said there, having reached conclusion issues 1 and 2, I therefore set up my findings on issue 8 causation on the assumption the contract of carriage was contained in evidence by the bill of lading and that owners were in breach of that contract. So just to be clear, the basis on which causation findings were made. And to the point, I might as well just touch upon it now, my learned friend played great store by it. nowhere does she say what breach she assumed. You'll see, for instance, at paragraph 62 of the judgment, the last line, in summarising certain of our arguments, she says it's submitted for the defendant if hypothetically Mrs. Bodin had been told by Gulf that the finance cargo was to be discharged at Sohar to STS vessels, she would not have objected, and thus the breach, i.e. delivery without production of the bill of lading, did not cause the loss. So a point we will come back to, but since it's very important to my learned friend's case, it is plain that she fully understood what the alleged breach was. And indeed, to Lord Justice Popplewell's questioning, there are, we submit when one looks at it, looking at the authorities, basis upon which there is in fact no breach at all. But it's really just in the context of the overview of where, and we say obviously you shouldn't, but should you fine for the appellant on grounds 1 and 2 and reject our respondent's notice, then we'll have to look at that issue in due course. Now, turning then to ground 1, and again repeat the caveat that things I think have moved on since certainly I drafted my oral submissions. But I just wanted at the outset to briefly look at the basis of this appeal as set out in the grounds of appeal. The court will find that in Core Bundle tab 1 at page 12. The first paragraph of ground 1 is that the judge erred in law in holding at paragraph 47 of the judgment the bank had not established that the bill of lading contained or evidence of contract after the novation of the charter party. So that's the only error of law identified by the appellant in that part of the grounds of appeal. And indeed, if one excludes the reliance on tort and bailment, it's the only alleged error of law relied upon at all. And it is contingent on the notion that after the novation, the bill of lading contained or evidence a contract of carriage, as you will see from paragraph 3, where it sets out what the judge should have found. After the novation, the bill of lading contained or evidence a contract of carriage, and the bank became lawful holder, accordingly, i.e. on the basis or as a result of 1 and 2, those rights were transferred to it. And it's important to note that, because that is the basis upon which the case was put to Mrs. Justice Moulder, and why she dealt with it in the way she did. It was said this contract contained, this bill of lading contained a contract, contained or evidence contract from the point of novation. We subsequently took the rights in that contract, therefore we have a claim. The grounds of appeal also complain that the judge failed to find for the bank in bailment or conversion, but failed to cite any paragraph in the judgment. And that's of course because it was not an argument run at trial and was conceded as concurrent with the contractual claim. Now, I don't understand from what Mr. Russell said that is actually pursued by him, so I will not say any more about it. It's also worth just noting, apropos of Lord Justice Popplewell's intervention, there's no mention in this grounds of appeal of a separate new argument not taken before the judge that somehow, even if they were wrong on all of this, a new contract arose in August, months and months after discharge, under which the bank is now entitled to bring its claim. Indeed, my learned friend showed a distinct lack of enthusiasm for that, refusing effectively to elucidate his case orally. So boiling down the grounds of appeal in context of ground 1, we're focusing, as I understand it, simply on the first part, so the alleged error of law in paragraph 47 of the judgment.
Well, are you saying that the point that he addressed in his skeleton and that you addressed in response in your skeleton isn't open to him, and we shouldn't address it, i.e. that irrespective of whether it was a contract of carriage at the time of discharge, the effect of section 2 is to make it one retrospective?
That will be our primary submission. It's not even part of the grounds of appeal, as you've seen. And I would say this, that it's dealt with in one very short paragraph. It raises very difficult issues. And if those issues have been properly ventilated, it would, I think, required significantly greater treatment. We did, rightly or wrongly, briefly outline our response, but those are very difficult issues. And at the moment, you have one paragraph, I think, in the skeleton from my learned friend simply asserting, and a second paragraph in the supplementary saying it has retrospective effect. That we would submit is unsatisfactory for a very difficult point of law, not raised in the grounds of appeal, not raised before the judge. There's no finding below from the judge that we can look at for no reason because it wasn't raised. So that is our primary submission.
Is it a difficult point of law?
Well, my lord,
if one were looking at a cargo claim, and what's slightly unusual about this is that the claim itself is for misdelivery. So if one's giving it retrospective effect, I understand your arguments about the contractual relations at the time. But if one were looking just at a cargo claim, and the bill were endorsed after completion of the voyage, but in circumstances where the spent bills provisions didn't apply under section 5 because it was under pre-existing arrangements, there wouldn't be any doubt that it would take retrospective effect if the charterer shipper endorsed the bill over after discharge.
Well, my lord, one of the points we'd submit is that my learned friends produced no authority that would be the case where the endorsement from charterers was only after discharge, and therefore, the problem we submit with this is that as at discharge, on this analysis, there was no contract under the bill of lading at all. We discharged, owners discharged, in accordance with the charter party being the only contractual duties it was under, and did so in accordance with that charter party on this hypothesis. We say that it's an extraordinarily odd result that a contract coming to existence only after the event can affect the performance of that very exercise.
Well, I know you do, and that's why I say that what's might be slightly unusual about the effect of section 2 and section 5 in this case is whether you can translate its retrospective effect to a misdelivery claim. But it's not controversial, is it, that it has retrospective effect and can give contractual rights by a contract springing up by endorsement after discharge is completed.
Well, again, without seeing authority to that effect, I accept that there are cases where there may be a transfer before discharge is completed and so forth. But for instance, the UU, which my learned friend relies upon, talks about the bill of ladings becoming spent upon delivery to the person entitled to delivery, even if it's without the bill of lading. So it raises this very difficult question. But my point to your lordship is that I submit that the position isn't quite as easy, particularly given the nature of the misdelivery claim here. The fundamental complaint that's made is based on a contract that on this hypothesis didn't exist at the time that act was carried out. So
just the same way as, well, suppose during the course of the voyage, let's not take an endorsement after the end of the voyage. The cargo is loaded, the shipper charterer takes the bill. It's not at that stage a contract of carriage, but at that stage of the voyage, there's damage to the cargo. So that if it were a contract of carriage, there'd be a breach of Article 3.2, let us suppose. And then before discharge, it's endorsed to the buyer, who's a third party. Contract springs up. The fact that there was no contract at the time of the breach in question doesn't prevent it having retrospective effect, does it?
Well, my lord, in certain circumstances, we accept that would be the effect of those provisions, that must be right. The question is whether it does so in this particular case, where the scenario is rather different.
Well, sort of taking it in stages, I can't myself see why it should be any different in the example I've given if the endorsement is post-discharge, because Section 5 says, provided that it's pursuant to earlier arrangements, and in the sort of trade where there may be a short voyage and a long chain of contracts, that's exactly what one thinks is intended to be achieved by Section 2 and Section 5. But just in stages, I'm talking about a cargo claim, which is not this case. I quite understand you might say, well, it's different where the claim itself is for misdelivery, and the effect of the act would be to operate retrospectively, where the owner has to decide at the time of delivery what his then existing contractual arrangements are. I understand that point, but that's it, isn't it? I mean, that's the, you say it raises a lot of difficult points. That's the point.
Well, that's the key point here, because that's the scenario with which we're dealing.
Yeah.
As I say, we're not aware of any authority directly on point saying that would apply more generally, but I accept the Lordship's observations in that respect. But this is about this specific question, and that's the difficulty which it raises. You know, that the wave of the hand to say, oh well, there's a fiction that the bill of lading contract, you were parties to the bill of lading contract, but actually in our submission what one has to look at is whether the endorsement or transfer of a bill of lading post-discharge would bring with it the right to claim damages for misdelivery when at the time of discharge there was only one different contract in place. I mean, it's a very, very odd result in our submission. It can't have been what was intended. At that stage, you know, owners were entitled and said obliged to discharge under the charter party, and did so. And it'd be odd if they were subsequently found, or that obligation was found to be affected by a later event. And maybe I'll come back to deal with it in a little bit more detail, if I may, in due course. But we do submit it. It raises serious, difficult issues, really difficult issues about retrospectivity in terms of the wider purview of the Act. So I'll certainly come back to your Lordship on that question. My Lord, I anticipate that in light of that, some or all of the submissions on the earlier part may or may not be academic, but I think it's important to look at them anyway, because this is the basis upon which the judge made her finding.
No, I'm certainly not suggesting otherwise.
My Lord, I appreciate that. And in our submission, her analysis, what she decided, and the basis upon which she decided was absolutely spot on. What I should say is that, as we understand it, reading the grounds of appeal together with the skeleton argument, and focusing just on this first part of ground one, that there are in fact two arguments, and they are that she should have held that upon or after the novation of the charter party, the bill of lading contained or evidence of contract of carriage between BP and owners, because, and this is certainly described as their primary case, the bill of lading in the charter's hands was not a mere receipt, but was always a contractual document. You'll see that's a statement in the supplementary skeleton paragraphs 5 to 7 at core page 187. And it said the failure to recognise or appreciate that is the fundamental flaw in the judge's reasoning and in our case. The secondary argument, and I think it is a separate argument, is that it said that the conclusion that upon novation the bill of lading did not contain or evidence of contract between BP and ship owners is wrong, because there's no reason why the situation after novation should be any different to the situation where the bill has been transferred to a third party. What I understand the bank to say there is, even if there wasn't a contract, this contract subsisting that had been suppressed, one sprang up upon novation, and they say it's exactly the same as if the bill had been transferred to a third party. So that, I think they are two slightly different angles. In response, we submit certainly the primary argument raised now at the heart of the case is, as we'll see, and the judge correctly found, unsupported by any text or authority, and indeed contrary to all those materials which were provided to the court below and to this court. And the secondary argument, insofar as it's different, also doesn't bear analysis. The simple assertion that the two parties' situation is the same is no substitute for an explanation of why it's the same. And that is what is missing in our submission from my learned friend's analysis. And again, we'll see, but the judge rightly noted the absence of any explanation of the bank's position for her. Now, in terms of the primary ground, as I understand it and explained, it suggests that the fundamental flaw in the judge's reasoning in our case is that we both take the wrong starting point, and I think that's the phrase my learned friend used earlier. It's said that the judge was wrong in her judgment at paragraph 22, which is on page 48 of the core bundle, where she said, "I understood it to be common ground that where a shipper is also a charterer of the bill of lading, is also the charterer of the bill of lading, is not the contract of carriage, but a mere receipt." As I've said, it is suggested now in the supplementary skeleton that the correct starting point is that the bill of lading is always a contractual document unless there's clear contrary intent. It's worth looking in the context of the analysis how it's expressed in the skeleton, the earlier skeleton. It's insightful in our submission as to the difficulties of this particular argument. And page 20 of the core bundle, in paragraph 26, what the bank says is that a better explanation may be that the bill of lading always has contractual status. It always contains or evidences a contract. They go on to say that somehow it is robbed of independent force in the two-party situation. We'll see that in the next line or so. Now, that is important because we'll see specifically the assertion that it always contains contains or evidences of contract is entirely unsustainable in light of the authorities. It's also, I think, worth, just before we dive into the case law, to observe that in this skeleton, as I think my own friend suggested orally, this is said to be a matter of construction. You'll see that at paragraph 23. In the supplementary skeleton, paragraph 10, on page 189, the alternative proposition is made that it should simply be treated as a rule of law. Now, my little friend didn't pursue that as I understand it, so I'm not going to address that. But that's how the case is made. As a matter of construction, the bill of lading is always a contract. Always evidences or contains a contract of carriage. Now, before coming to look at the merits of that in a little detail, it's worth putting it in context. The amended defence, which the court will find at tab 10, made the point that paragraph 7.2 on page 111, that as at the 19th of February, the contract of carriage between BP and the defendant was contained in and evidence by the charter party and not the bill of lading. And the bill of lading was a mere receipt in the hands of BP, so a conventional position we submit. And at 7.4, we go on to deny that the bill of lading contained in evidence a contract, or the contract of carriage as soon as BP ceased to be charterers, and highlight further down the absence of any basis upon which is alleged the bill of lading contained or evidence that A or the contract as soon as BP ceased to be charterers. That was the pleading from our side. The response is in the next tab. And what the court will find, if I ask you to turn to page 137, right at the bottom, paragraph 5, the bank admits and continues to admit, it's unamended, that the bill is a mere receipt. So it admits paragraph 7.2, which I took the court to. Indeed, as the court will see from paragraph 7.1 on the next page, what it actually pleads is the bill of lading contained and or evidenced the contract at the point at which the bill of lading was no longer in the hands of the charterers. That's their expressly pleaded case, and indeed they go as far as to say at 7.3, where the original charterer ceases to hold the bill of lading as a mere receipt, a new contract on the terms of the bill springs up with a retrospective effect at common law. And the consequence is said at 7.4 to be in the premises on the 6th of April upon the novation, and upon the bill of lading no longer being a mere receipt in the hands of BP, the bill of lading contract sprang up. And again, that's repeated for completeness sake at paragraph 8. So this primary argument and the heresy in our argument in the judge's judgment is one which was common ground, and one I think can see why the judge understandably stated in her judgment that she understood it to be common ground. It was on the pleadings, and indeed I don't think we need to go to it, but the way it rose was a faint reference to this possibility of the bill of lading maybe possibly being a contract all along was made in the opening skeleton at trial. And the second point that comes from this is that those pleadings are an insight, if I might say, into the understanding of highly experienced counsel pleading out this case as to what the position was, and what the position is. Their understanding in our submission is entirely in accord with what we submit is the conventional and indeed the correct analysis, and that's maybe more than a forensic nicety in this context. It's what all of us shipping lawyers, and sometimes we get it wrong, but all of us shipping lawyers have for a very long time understood to be the position. In that regard, setting aside my forensic observations on the pleadings, it is a well-established position. In our submission, it is beyond doubt the position. There are two sides of the particular coin. The first is, as I briefly mentioned, the absence of any support at all for their contrary analysis. I think it's still fair to say that even on this appeal, they've been unable to cite a single authority or textbook to support the notion that the bill of lading was always a contractual document or contained or evidence contract throughout. And I think my learned friend rather manfully referred to Rodonacci case, but indeed that in our submission is a case that's fairly and squarely against him on this issue. I will then perhaps deal with the authorities briefly, because we say they all point one way, but in context of the judgment, she quite correctly observed the appellant's inability to cite anything that supported their much more nuanced and much more cautious approach in her judgment. When we're looking at the criticism angle at the judge in respect, it's not justified. She listened, and she listened to what was said, and she properly saw that there was no support for this heterodox proposition. Now, the flip side is, as I've said, that the texts and authorities speak with one voice, namely the bill of lading in the charter's hand is a mere receipt, and it doesn't contain, nor does it evidence, a contract. The court will have seen, and I'm conscious of the indication that they've read it carefully, but in paragraphs 27 to 43 of the judgment, the judge carefully sets out a selection of authorities and textbooks that confirm the position with admirable clarity. Now, I don't want necessarily to go through them solemnly in detail, but I do think it's worth just taking the court back to one or two just to show why the judge was right in her finding. The first case is Rodokanachi at tab 2. My learned friend, I think, explained that it concerned the charter party between the plaintiff and defendant. The bill had exceptions not in the charter party. The loss was caused by negligence covered by the bill of lading exception, but not the charter party. What the court held was that the charter party didn't authorise the bill of lading with that exception, but even if it did, the charter party was the contract and the bill of lading was a mere receipt. So that's the context of the observations. And the court will find the passages I think my learned friend may have taken you to on page 40. There's two passages there, one sideline, one is not, but the starting point is a passage my learned friend, I think, cited. It seems to me that in either of the views I've been expressing, the case is really covered by authorities, expressly hold that as between the charters and the ship owners, the bill of lading does not alter the contract between them contained in the charter. And further down the same page, just next to the hole punch, the Lord Isha continues, in my opinion, even less so here, even so, unless there is an express provision in the documents to the contrary, the proper construction of the two documents taken together, as between ship owner and charter, the bill of lading, although inconsistent, certain parts is to be taken only as an acknowledgement of the receipt of goods. And further down, he says, this doctrine gives effect to both instruments, because although, as between ship owner and charter, the bill is only a receipt for the goods, it will be a contract upon the holder of the bill of lading to whom his endorsed must rely as between himself and ship owner. This might also, whilst we're in this authority, just direct the court to passage in Lord Justice Linley's judgment on page 43. And this is a passage that's also relevant, we submit here, and also in establishing what we submit as the proper approach to considering whether a contract would have arisen upon novation. It's about halfway down, and I hope you pick up a sentence starting. It was argued that reading the cessor of liability clause and the 10th clause of the charter party together, an intention was shown that a new and different contract from the charter party should be created as between the plaintiff and defendant by the bill of lading. I cannot see on the documents any trace of such intention. The authorities show prima facie, and in the absence of express provisions to the contrary, the bill of lading as between the charter and the ship owner is to be looked upon as a mere receipt. We'll come back to this, but the judge is identifying the presumed intention of the parties as relevant to the approach that he is adopting. And then, just for completeness' sake, there's a passage at the bottom of page 44 leading on to 45 in Lord Justice Lope's judgment. 4 lines up, I believe the law to be that when there is a charter party between charterers and ship owners, the bill of lading operates prima facie as a mere receipt and a document of title which may be negotiated and by which the property is transferred, but does not operate as a new contract or alter the contract contained in the charter party. conscious that that clock is slow, lady, so that might be a convenient moment to break.
Yes, thank you very much, Mr. Thomas, and I assume that you're proceeding as you expected.
Well, yes.
Thank you very much. On that basis, then, we'll begin again at 10:30 tomorrow.
All right.